Arbitral tribunal can be of two types. One is individual arbitrator, or as the case may be, it may be an institutional arbitrator. Institutional arbitrator are of various types, as we already know: SIAC, London Court of International Arbitration, Delhi Court of International Arbitration. Now what happens is that when there is an emergency requirement, you have to press that button, and that emergency button is emergency arbitration, recognized and enforced under section 17(1) of the Arbitration Act. There is a celebrated case of Amazon versus Future Retail. The Amazon invoked the jurisdiction of SIAC, and SIAC had that institutional mechanism for emergency arbitration. Future Retail said that no, we want to sell our assets to Reliance, and no, you cannot stop us because we do not agree to emergency arbitration. Supreme Court said that ultimately autonomy of the party is the king. If you agree to SIAC as an institutional arbitration, then all other emergency provisions or institutional provisions will naturally follow. And you cannot selectively say that no, we agree to this particular part of institutional mechanism and not to the remaining part of it. And therefore, by this particular judgment, Supreme Court recognized the validity of the emergency arbitration under section 17(1). Now we will also talk about section 17(2) because it is a related provision. Earlier, the interim awards by the arbitral tribunal were considered to be toothless tiger. Because ultimately, if there is an interim award, if the courts of India refuse or are very slow in recognizing the same or enforcing the same, then crucial time will go. By the time the award is passed, the water has flown, and then what is lost you cannot recover. But in 2015, there was a major amendment to the Arbitration Act. This amendment gave much needed teeth to this particular section. Now the interim awards which are passed by the arbitral tribunal are very much enforceable. Now non-compliance will amount to contempt. You can also invoke the execution mechanism under the CPC for the enforcement of this kind of interim orders by the arbitral tribunal, and therefore collectively section 17(1), section 17(2) give much needed teeth to the arbitration to protect the interest of the contracting parties, and therefore the arbitration environment in India is very much improving. And as we go forward, we'll also discuss about how the awards are passed, how the awards are enforced, and if there are any corrections required, how those corrections can be sought. If there is a challenge to the same, how those challenges can be made to the arbitral award.